War Hazards Compensation Act, WHCA explained. What government contractors need to know. If your company performs work overseas under a United States government contract, you've probably heard of Defense Base Act insurance. But there's another law many contractors know very little about. It's called the War Hazards Compensation Act, or WHCA. Although it isn't discussed as often as the Defense Base Act, it plays an important role in overseas government contracting. Today we'll explain. We'll keep everything simple and easy to understand. What the War Hazards Compensation Act is, why it exists, how it relates to Defense Base Act insurance. What is the War Hazards Compensation Act? The War Hazards Compensation Act is a federal law that helps address certain claims arising from war-related hazards. Applies to employees covered under the Defense Base Act. Recognizes unique risks faced by overseas contractors. Why was the law created? Imagine a contractor working on a military base, embassy, or infrastructure project overseas. That contractor may be exposed to risks that simply don't exist on most domestic construction projects. The WHCA was created to address these unique hazards. Hostile acts, acts of war, terrorist activity. Does WHCA replace Defense Base Act insurance, DBA? No, this is one of the biggest misconceptions. DBA remains the primary workers' compensation coverage for many overseas contracts. WHCA works alongside the DBA under specific circumstances. Think of WHCA as a separate federal program for qualifying war-related injuries. Another way to look at it, the Defense Base Act provides broad employee protection for covered overseas work. The War Hazards Compensation Act helps address injuries caused by war-related events. The two laws are connected, but they serve different purposes. What types of events might involve the War Hazards Compensation Act? Examples may include injuries resulting from every claim is different, and WHCA does not apply to all overseas injuries. Hostile attacks, acts of war, terrorist activity, enemy action, certain military-related hazards. Who should understand the War Hazards Compensation Act? Understanding the law is part of good risk management. Construction contractors, engineering firms, defense contractors, logistics, maintenance, security, infrastructure, utility contractors, subcontractors performing work overseas. Does working overseas automatically mean WHCA applies? Incident facts are often more important than location. No, simply working outside the US does not trigger WHCA. Injury circumstances, contract terms, and legal requirements all matter. Each claim must be evaluated individually. WHCA is not limited to active combat zones. Why should contractors care about WHCA? Understanding the law helps companies better prepare for overseas operations. Contract compliance, insurance planning, employee protection, risk management, claims administration. One of the most common misconceptions, contractors think they must interpret complex federal laws on their own. Fortunately, that's usually not necessary, can all help. Experienced insurance advisors, legal professionals when needed, claims specialists. Planning ahead is one of the best forms of risk management. Before employees travel overseas, contractors should review government contract details, insurance requirements, employee assignments and location, contract duration, subcontractor obligations, emergency response procedures. Let's look at a simple example. Understanding WHCA matters. Two contractors working overseas. One has routine workplace injury, unrelated to hostile activity. Another has injury from a qualifying hostile event. Both may have DBA coverage, but claim handling may differ due to WHCA's involvement. It is important to remember, not every overseas injury qualifies under the War Hazards Compensation Act. Each case depends on facts, applicable law, and claim evaluation. Avoid making assumptions based on rumors or internet discussions. Best business practices, preparation can help prevent larger problems later. Ask questions before work begins. Review your contract. Understand your insurance requirements. Know your insurance advisor. Develop a plan before employees mobilize overseas. To summarize, the WHCA is a federal law connected to certain war-related injuries involving employees covered under DBA. It does not replace Defense Base Act insurance. Works alongside DBA for qualifying circumstances. Companies performing overseas government work should understand both laws. Most importantly, do not rely on assumptions. Review your contracts carefully. Work with experienced professionals who understand government contracting requirements. Thank you for joining us today. We hope this webinar helped explain the basics of the War Hazards Compensation Act and its relationship to Defense Base Act insurance. If you found this valuable, like, subscribe, and share. Need a second opinion on your insurance program, contract requirements, or risk financing strategy? Visit montridgeinsurance.com. Schedule a confidential discussion today. Thanks for watching. We look forward to seeing you in the next webinar.